continuation of State of Tennessee versus Tremaine Wilbourn, docket number 16000515. Mr. Wilbourn is present. Mr. Ganguly, Ms. Pasley, Ms. Hall are present. Mr. Wilbourn, Mr. Wyers Henderson, and Ms. Bird are present for the state. The state arrested its proof, had concluded its proof at the end of yesterday on the sentencing hearing. Mr. Ganguly, does Mr. Wilbourn have an additional proof that he wants to submit a sentencing?
We do, Your Honor.
Are you ready to proceed with sentencing?
There's an offer of proof regarding Dr. Turner.
Yes, sir. Dr. Turner. Come forward, please, sir.
Come around, sir. This way. I'm going to still raise your right hand, Dr. Turner.
Dr. Turner, good morning, sir. Dr. Turner, do you solemnly swear or affirm the testimony you've given this cause to be the truth, the whole truth, and not but the truth, so help you God?
I do.
Thank you, sir. Mr. Ganguly has your folder for you. You may have a seat on the witness stand here and watch your step, please, sir. Dr. Turner, how are you this morning, sir?
Pretty good.
Mr. Ganguly, please proceed.
Could you please tell us your name for the record?
Erlanger Turner.
What's your profession, please?
I'm a psychologist.
I'm going to pass to you a document, and I'll ask if you recognize it.
Yes.
All right. And are you an assistant professor of psychology
Correct.
at the Department of Social Sciences at the University of Houston?
Yes.
All right. And just for purposes of the record, can you list your full profession, please?
My full profession is I'm a psychologist, a clinical psychologist, and assistant professor.
All right. How long have you been doing that? How long have you been in practice?
I've been licensed to practice since 2011.
Could you please tell us your educational background?
I have a PhD in clinical psychology from Texas A&M.
All right. And where did you do your pre-doctoral psychology internship?
I did my pre-doctoral internship at Florida State University.
Did you get a master's degree in clinical psychology?
Correct.
Where and when was that?
I graduated in 2006 with my master's degree from Texas A&M,
Where did you obtain your bachelor's degree, please?
Louisiana State University.
All right. And just to be clear, you've obtained a PhD
Correct.
in 2009
Correct.
from Texas A&M University.
Yes.
All right. Can you please explain the professional training to the court?
I got my PhD in clinical psychology in 2009. Following that, I did 2 years clinical postdoctoral training at Kennedy Krieger through Johns Hopkins University School of Medicine. And following that, I became licensed as a psychologist, and then I entered into private practice for several years.
All right. What states are you licensed?
Previously licensed in Maryland and currently licensed in Virginia and in progress for Texas.
Are you the director of the Race and Cultural Experiences Research Laboratory at the University of Houston?
Correct.
And tell me about your role as the director there, please.
As the director of that center, I basically conduct research on issues related to race, mental health, and also supervise undergraduate psychology students in learning about research.
Do you belong to any professional societies?
Yes, I'm a member of the American Psychological Association and the Black Psychology Association.
All right. Have you been invited to speak at any seminars?
Yes.
Could you tell us about that, please?
I've presented nationally at numerous conferences and also talked to Congress, did a congressional review.
All right. Is it fair to say that you were the inaugural speaker for the American Psychological Association in March of 2017?
Correct.
What did you talk about at the American Psychological Association's meeting?
At that particular event, I talked about policing and its impact on people of color, specifically African Americans.
All right. Have you testified in court proceedings before?
Yes.
Have you had an opportunity to review Mr. Wilbourn's records in this matter?
Yes.
What records have you reviewed?
I've reviewed interviews from witnesses as well as from Mr. Wilbourn.
Did you review juvenile records?
I did have some of the records that were sent to me, correct?
Did you review Mr. Wilbourn's mental health records from Alliance?
There was documentation that listed specific diagnoses.
Okay. Have you met Mr. Wilbourn?
Yes.
Where and when did you meet Mr. Wilbourn?
I just met him today.
All right. The mitigation in the context of the sentencing phase of a capital murder trial.
Yes.
Based on a reasonable degree of psychological certainty for an individual in your field, are you able to substantially assist the court in providing information pertaining to issues that affect mitigation in this matter?
Yes.
Judge Bannon, mark Dr. Turner's curriculum vitae as an exhibit for ID only.
Yes, sir. Any objections from the state to this officer?
No, Your Honor.
And for the record, this would be admitted for purpose of identification only as Exhibit A as an apple. This is the curricula vitae of Dr. Erlanger, E-R-L-A-N-G-E-R, last name Turner, T-U-R-N-E-R. This is a 6-page document. Exhibit A is an apple of identification purposes only. Mr. Gangle, you may proceed.
Thank you, Judge. At this point, we tender Dr. Turner as an expert in clinical psychology.
As an expert in clinical psychology, any objections to the tender of Dr. Turner as an expert in clinical psychology?
One moment, Your Honor.
Yes, ma'am.
I don't have an objection to him being called as an expert in clinical psychology. We would object to him being declared any sort of expert in the area of race-related trauma or the area of mitigation. I don't think he's established that.
And for the record, in his general field of clinical psychology, the court will in fact declare Dr. Turner is an expert in his field of clinical psychology. Mr. Gangle, you may proceed.
Point of observation.
Yes, sir. Mr. Gangle, you may proceed.
Judge, in terms of mitigation, we would agree. However, since Dr. Turner has presented at the American Psychological Association and has spoken regarding race-related stress and inclusive policing, we would submit that he would be an expert in the area of policing and the impact of it among African Americans.
Ms. Gangle, you may develop any other testimony that you want as far as that field or any questions that you want. It's a hearing for the record pursuant to Tennessee Roosevelt Weiner 03. This is an out of jury hearing. The jury, for the record, is not present in the courtroom. The state has made an objection to a proposed testimony that's reflected in the document that Ms. Gangle has provided to the state. It has been provided to the court a confidential report regarding some proposed testimony that Dr. Erlanger Turner would present before the jury. And that's the purposes here at this point, to see whether or not that testimony is in fact admissible, whether or not it's relevant, whether or not it meets the criteria for admissibility for expert testimony in that particular field. So until I take the testimony on that, Mr. Gaines, who I will not declare an expert in that topic, I will declare an expert in clinical psychology. You may proceed with any other questions at this point.
Thank you, Judge. Have there been studies on the effects in the community of police shootings of African Americans?
Yes.
Tell us about those studies, please.
There have been several studies. There were two most recent studies that were just published in 2018, looking at some data between 2015 and 2017. One of those studies was looking at a national study of over 30,000 individuals, trying to look at where there are impacts of watching or witnessing policing in the communities, comparing African American as well as white individuals and what their responses were to witnessing those events. The data from that particular study basically demonstrated that for African American individuals that they suffered more mental health negative outcomes as a result of witnessing police shootings or being aware of those shootings. And those African Americans specifically reported increased levels of stress and depression after witnessing those events. However, for white individuals, there were no significant differences in terms of their mental health outcomes after witnessing these incidents. There's also been additional studies that have looked at this impact and specifically centered around incidents in Ferguson. And that data also demonstrated that for African American community members, that they had increased rates of post-traumatic stress disorder, or PTSD, and those levels were in the clinical levels for African American individuals, but not for other individuals in the community.
Yes, sir. Dr. Turner, how do the instances of police shooting African Americans create negative impacts in the African American community?
Based on my knowledge and the research, the individuals may experience increased rates of things like anxiety or stress, as well as hypervigilance. And the research also demonstrates that it does have some negative impacts on changes in the brain, and those changes can also be passed on to offsprings as well.
Do police shootings only impact those in the community where the shootings happen, or is the impact broader?
Based on my knowledge, the impact does tend to be a broader impact, so individuals that are not just in cities where those incidents have occurred experience negative impacts, but also those outside of those communities as well, from witnessing those things through media.
All right. Dr. Turner, what is race-related stress or racial trauma?
Race-related stress or racial trauma is experiences of negative psychological effects, including things like anxiety, depression, increased agitation after the witnessing or experiencing some incidents of racism or discrimination.
Based on your review of Mr. Wilbourn's records, do you believe he exhibits signs of race-related stress?
Yes.
How?
Based on review of records, it appears that he reported some symptoms of anxiety as well as some hypervigilance and increased tendency of arousal.
Okay. Based on your knowledge, have there been instances of police shootings of African Americans in the months leading up to the night of August 1st, 2015?
Yes. There were several reported over the course of the summer, and some of the data that I looked at show that there was at least one incident in July that occurred in Memphis.
And based on your research, would those instances of police shootings of African Americans have impacted the community?
Yes.
Are you aware as to whether Mr. Wilbourn had a diagnosis of post-traumatic stress disorder?
Based on records, it did indicate a diagnosis of PTSD.
And what is post-traumatic stress disorder?
The disorder includes a number of different symptoms. One of those includes either witnessing or experiencing some traumatic experience. It also is associated with increased fear related to the environment or trusting others. It also includes symptoms of increased hypervigilance or arousal, as well as being able to try to block out the intrusion of memories that are related to the traumatic event.
Is post-traumatic stress disorder also known as PTSD?
Yes.
How does PTSD affect individuals?
PTSD puts individuals at risk for experiencing things like flashbacks or bad dreams or nightmares, as well as having difficulties in terms of trusting others, as well as being able to potentially have hypervigilance or concern about a fear in the environment.
All right. Does PTSD affect individuals' reactions to situations of crisis?
Yes.
How?
It makes them more on alert for threatening situations and potentially responding in a way that has increased agitation.
Could Mr. Wilbourn's diagnosis of PTSD have impacted his response to the events of August 1st, 2015?
Yes.
How?
Given the diagnosis and the previous history, being in that particular situation may have elevated his tendency to be perceiving of threat in the environment, in addition to the experiences of the shootings that were occurring in the United States around that time period.
Could Mr. Wilbourn's childhood trauma impact his response to the events of August 1st, 2015?
Yes, it's possible that traumatic experiences that have occurred in someone's life lead them to.
How would the childhood trauma and diagnosis of PTSD impact race-related stress in an individual?
Those particular childhood experiences may put someone at an elevated risk of perceiving threat or harm in the environment.
Okay. Have you prepared a written report based on your review of the documents you described and your knowledge and experience as a psychologist in this matter?
Yes.
May I ask you about it? I'll ask if you recognize it.
Yes.
Or may I have that report the Dr. Turner prepared to mark as the next exhibit for ID only?
In objection to the mission of this report for identification purposes only at this time.
No, Your Honor.
And this will be admitted as Exhibit B as in Boston. This is a confidential report, State of Tennessee versus Tremaine Wilbourn, prepared by Dr. Turner. The dates of the report summary is indicated as October 24th, 2018. It's a 14-page document, Exhibit B. Gangley, you may proceed.
Thank you. Finally, are all of your opinions expressed today to a reasonable degree of certainty for a licensed clinical psychologist?
Yes.
Thank you. No further questions, sir.
Ms. Bird, you may proceed.
Doctor, have you ever been qualified to testify about race-related trauma in a court forum?
No.
Do you know of anyone who's been qualified to testify on that issue?
Yes.
It is not a recognized race-related trauma. It is not recognized by the Diagnostic and Statistical Manual.
It is not a psychological disorder.
It is not a psychological disorder or a psychological disease. Correct?
It is recognized as a psychological symptom as well as a syndrome,
But not by the Diagnostic and Statistical Manual.
but not as a
correct?
disorder.
The Diagnostic and Statistical Manual, sort of the Bible for the diagnosis of mental diseases and disorders.
Correct.
And so there is no criteria set forth for diagnosing something called race-related trauma, correct?
Correct.
And in fact, don't you indicate that it is difficult to come up with a criteria for diagnosing or for identifying these sorts of symptoms?
Correct. They're still identifying the criteria.
And don't you also indicate that it's difficult to identify under what circumstances an individual will develop what you call race-related stress?
Yes, because people experience it differently.
And don't you also indicate in your report that there needs to be improvement before there's an understanding of how race-based encounters and experiences produce potential psychological injury?
Consistencies across particular
So
conditions.
there's not yet any set criteria for identifying those factors, correct? No set criteria for identifying what types of trauma might lead to race-related stress, correct?
Correct.
No set criteria for diagnosing someone or identifying their symptoms as being related to race-related trauma, correct?
Correct.
In fact, the defendant's diagnosis of post-traumatic stress disorder was not based upon reports of these sorts of experiences, but was based upon his childhood, correct?
Correct, but the diagnosis of PTSD doesn't have to be related to racism to exhibit some symptoms.
And his report as to how that diagnosis was made was based upon his reports related to his childhood trauma, correct?
Correct.
And his childhood circumstances,
Correct.
not based upon viewing certain instances or having certain race-related incidents occurring.
Not to my knowledge.
You indicated that the range of things that are currently that you considered that might be incidents that could lead to this type of trauma, or anything from name calling to actual violence. Is that correct?
Correct.
You didn't perform a clinical evaluation yourself of the defendant in this case,
I did not.
and you've not diagnosed him with anything.
Correct.
Your practice, correct?
I also work with adults. I work across the developmental spectrum.
Children and adults.
Correct.
But you're not, your practice has not focused on the psychological issues based primarily with defendants or criminals, correct?
No.
And you indicated that the anxiety and hypervigilance that you talked about as possibly being related to race-related traumas is the same for a diagnosis of post-traumatic stress disorder, correct?
Correct.
But you also indicated in your report that based on current diagnostic criteria, it's not appropriate to diagnose race-related stress using the criteria for post-traumatic stress disorder, correct?
Right. There are different criteria.
Well, there is no set criteria for the
Right. Well, there will be different criteria. Correct.
So you're indicating if there were, the criteria would be different.
Potentially.
So the defendant's diagnosis of post-traumatic stress disorder does not necessarily relate to race-related trauma, correct?
Correct.
Yes, ma'am.
Did you indicate in your report that there was no documentation was provided to confirm or deny that these symptoms were related to results of experienced racial incidents?
I did.
Did you also write that it remains unclear under what circumstances racism leads to trauma, race-related stress, or symptoms of post-traumatic stress disorder?
Yes, correct.
And that was based upon one of the studies that you had reviewed as the basis for your opinion?
Well, it's based upon the studies and just the current status of the research.
And essentially, the current status of the research is that it's in its infancy and there's no real criteria or structure to it yet. Is that correct?
Correct.
You indicated, in fact, that more study was necessary before, in fact, this would be developed as an appropriate syndrome or disease or defect, correct?
Correct.
And other than those articles that you've mentioned, you didn't conduct personal research in this area,
My research is currently ongoing related to this area.
that you have no published research.
It's not published,
that's
correct.
specific to this issue
Correct.
currently. And the research that you reviewed was related to shootings that involved unarmed suspects. Is that correct?
Both unarmed and armed.
Did you mention repeatedly in your report that these were related to unarmed individuals?
It discusses both.
Isn't it fair to say, as you mentioned in your report, that you cannot document that those symptoms that the defendant is experiencing are related to racial incidents?
Could you rephrase that question?
No documentation was provided to confirm or deny that these symptoms are the result of experiencing racial incidents.
Correct, yes.
No further questions, John.
Is there any additional questions? Yes, sir.
Dr. Turner, does your report note that socioeconomic status is significantly negatively related to psychological distress?
Correct.
Can you please explain that?
So basically the research documents that individuals that live in lower income communities tend to report more significant psychological difficulties related to the environment.
Or, Dr. Turner, had Mr. Wilbourn yelled words to the effect of "get your cameras out, you're trying to kill us," does that indicate race-related stress or trauma?
Object, Your Honor, and speculation. I don't think that the doctor can tell what is in the defendant's head at that time. The meaning of those words or what they were to the defendant at that time, I don't think, even given the clinical background or putting it in that context, that he can say. And in fact, we just met him today, so he cannot know, even put that in any sort of context as it relates to the defendant.
May I respond to that?
Yes, sir.
Brother, he's presented on this very topic and has been tendered as an expert, then he can speculate.
We've objected. That's what
Experts
the point
can't
of this is.
speculate, Mr. Gang, we're looking at opinions, but they can't speculate. Speculation is never allowed by any witness, whether an expert or a lay witness. In fact, the tell the jury cannot base a verdict on speculation. An expert may give an opinion that is logically related to his field, but he cannot speculate. He cannot guess what may have been in somebody else's mind. He can give an opinion if it's reasonably related to his testimony, but he can't guess or speculate as to what someone else might have thought.
Mr. Does it's a poor word choice on my part.
Yes, sir.
Then he can certainly offer his opinion.
You may rephrase the question, Mr. Angulo.
All right. Thank you. And the fact that, and again, the fact that Mr. Wilbourn yelled, "Get your cameras out, they're trying to kill us," in your opinion, Dr. Turner, does that indicate race-related stress or trauma?
Yes, and in my conversation with Mr. Wilbourn this morning, he talked about how witnessing those things in the media had been something that was stressful for him prior to that event.
Thank you. Nothing further, Your Honor.
Is there any additional questions?
And that's based on your conversations with him this morning after you've written a report.
Correct.
Nothing further, Your Honor.
Any additional questions, Mr. Gangool?
No, sir.
Dr. Turner, this subject of race-related trauma, is that correct, sir?
Correct.
You've indicated that there are no criteria for this this subject field at this point. Is that correct?
Correct.
And you've also indicated you've never been qualified as an expert at race-related trauma regarding African American males and female students. Is that correct?
Correct.
Are you aware of the fact that there was no police shooting in this case?
I'm sorry, could you
There
repeat
was no police shooting. Are you aware of that?
that there's no police shooting?
Yes, sir.
I was not aware of
You're
that.
not aware of that. Were you not aware that Officer Bolton never fired a shot in this case?
I don't recall it.
So you're not aware that he never fired a shot? You're not aware that he never, in fact, unholstered his gun?
I do recall reading that.
Were you aware of the fact that he never even took the safeties off his gun so he could even unholster or pull his gun?
I was not aware of that.
So all of what you told the court is based on the premise that a police officer might be shooting at somebody else or threatening to shoot someone else?
Correct.
So if that's not the factual situation in this case, what you just testified to the court would not be relevant. Is that correct?
I don't know how to answer the question.
The proof that the jurors heard is that Officer Bolton arrived at a location where a car was parked illegally, put his spotlight on the car. One person immediately dropped out of the car, grabbed as much marijuana as he could, and fled. Mr. Wilbourn stayed behind in the car, a lot of marijuana all over the car, marijuana residue and scales. And apparently the police officer approached Mr. Wilbourn, started putting out part of his call signal, did not even have enough time to put out all of his call signal. There was nothing else heard on that tape. No threats by, nothing said by the officer at all. And Mr. Wilbourn was not reported as saying anything. Get your cameras out there trying to kill us. None of that was recorded. And the witnesses testified that Mr. Wilbourn and the officer were involved in a struggle. That Mr. Wilbourn pushed the officer, stepped back, fired one shot. That apparently shot the officer in the face and then fired 8 other shots, 7 other shots at Officer Bolton while they lay prone on the ground. Officer Bolton never pulled a gun, never fired a gun, apparently never attempted to pull a gun because the safeties on his holster, 3 safeties were all in a locked position. So what you just told the court involves police shootings. It would not appear to have anything to do with this case. Would that be a fair statement?
Correct.
And what you also told the court is that the race trauma is something for which there's not been tested, there's no methodology for it, and they're still under development, but a lot more research needs to be done. Is that correct?
Correct.
Has this information been subject to any peer review or publication?
Yes.
Whether, I also have to consider whether or not there's a potential error rate, and there's no error rate that is known because there's no studies that have been done in which this can be validated at this point. Is that correct?
I would disagree with that.
Is this race trauma something that is generally accepted within the scientific community?
Yes.
And lastly, have you conducted any independent research that has been published on this area?
Yes, in progress.
It's in progress. And I go back to the initial question, if your testimony is that in some cases involving police shootings, that this may be relevant or it may happen in some cases, if there's not a police shooting, Officer Bolton never pulled his gun, never fired a shot, his gun was never unholstered, would any of that testimony be relevant for this factual situation?
Yes.
How so?
Based upon the research of thinking about incidents outside of that particular experience.
And what you told the court, Dr. Turner, is that some of this may be relevant. You talked to Mr. Wilbourn today, is that correct?
Correct.
And are you telling me that these are things that were present? Or are you simply telling me that could be a factor or it could be something that Mr. Wilbourn could have thought about? Because you have not told me that just coffee, these are definitely factors that affected Mr. Wilbourn and what he did. But you told us that based on your review of the limited material you have, and apparently did not know that Officer Bolton did not pull a fire a gun, you're telling me that Mr. Wilbourn may have been under some stress or may have been under some post-traumatic stress disorder related to other police shootings across the country. Is that correct?
Correct, in addition to his diagnosis.
In addition to his diagnosis of post-traumatic stress syndrome. Is that
Correct.
correct? What are you telling me, and will you ever tell a judge that based on your limited interview with Mr. Wilbourn, that in fact this is something that did affect him?
I can't.
You
I
can
can't
never get that opinion.
Yeah, correct.
Ms. Gangula, additional questions?
No, thank you, Judge.
Ms. Bird, any additional questions?
No, Your Honor.
Is Sylvester Turner still the mayor of Houston?
Yes.
Went to law school with Sylvester Turner.
Okay.
So tell His Honor Judge Coffin says hello when you like to do so.
Okay.
Thank you, sir. Step down, Vice Chancellor. Mr. Gangula, any statements or arguments regarding the admissibility of this testimony? Yes, sir.
Well, we would rely on our argument. We would respectfully ask that he be allowed to testify.
Ms. Bird, any statements or arguments regarding the inadmissibility of this proposed testimony?
We do, Your Honor, rely on the argument that we previously made. I think Your Honor's questions went to those issues that we'd addressed.
For the record, in recognizing that this is a sentencing hearing on the capital murder case and the rules of evidence are a lot more relaxed for sentencing. But in order to be admissible, there still has to be bare bones admissibility standard, and understand that Mr. Wilbourn has the right to present defense, has the right to present mitigation testimony. But in order to be relevant, relevant evidence under 401 is defined as evidence having any tendency to make the existence of any fact that is a consequence to the determination of action more probable or less probable than it would be without the evidence. If it's relevant under 401, it is in fact admissible under 402. But under 403, even if it's relevant, evidence may be excluded if the probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issue, misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of evidence. Rule 101 of the Rules of Evidence indicate that these rules shall govern evidence rulings in all trial courts of the state of Tennessee. And Rule 102, Purpose of Construction Clause, mandate that these rules will be construed to secure the just, speedy, and inexpensive determination of proceedings. Tennessee Rules of Criminal Procedure Rule 2, Purpose of Construction, again, mandate that these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure A, simplicity in procedure, B, fairness in administration, and C, the elimination of either unjustifiable expense and delay, or secondly, unnecessary claims on the times of jurors. Dr. Turner has been presented to the court as an expert. He is, in fact, an expert in clinical psychology. Rule 702 would mandate rather that if scientific, technical, or other specialized knowledge will substantially assist the trier of fact to understand the evidence or to determine a fact in an issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise. But 705 would further mandate that the expert may testify in terms of opinion or inference and give reasons without prior disclosure of the underlying facts or data unless the court requires otherwise. The expert may, in any event, be required to disclose the underlying facts or data on cross-examination. State of Tennessee filed a motion for discovery in this case many months ago. This court has conducted hearings on this case, has conducted hearings in which there have been multiple complaints by the state indicating we've requested reciprocal discovery, have not been provided discovery of some things, including of the expert in this case, and Tennessee Rules of Criminal Procedure will also mandate that once a request for discovery has been made and the state makes a reciprocal request for discovery, that those reports, those matters that are in the hands of an expert should in fact be provided to opposing counsel. And the state has complained many times. Just Coffee, we continue to request discovery. We have not been given discovery on any reports of examination and tests that may have been done in this case by an expert. And it is mandatory that those items be turned over once discovery has been complied with by the state. This report is dated October 24th, 2018. This case was set for trial many months ago. I don't know when Dr. Turner was retained to assist Mr. Wilbourn on this case. My understanding is the state of Tennessee was given a copy of this report Wednesday, Thursday before trial, and the state has had this document in their possession for less than 2 weeks. If I'm mistaken, the lawyers will correct the record, but that's my understanding. The state has had this information for less than 2 weeks. State versus Hall, H-A-L-L, 958 Southwest 2nd, page 679 of 1997 Tennessee Supreme Court opinion, indicates that expert testimony is admissible to show that it caused a mental disease or defect. In this case, Dr. Turner says post-traumatic stress syndrome and others that led to an unrecognized at this point by the medical community, by the psychological community, by the Bible of psychological disorders, racial trauma, would indicate that expert testimony is admissible to show the cause of a mental disease or defect the defendant lacked the capacity to perform the mental state required to constitute an offense of which he or she has been tried. And if the testimony does not tell me what Dr. Turner tells me, is that it cannot tell me, cannot, and will not tell this court that Mr. Wilbourn was in fact suffering from or experiencing racial trauma because of post-traumatic stress disorder, but simply that he might have been, that he could have been, that it's a possibility that those things may have existed and may have affected or caused him to take some actions that he took in this case. Hall, Ackerman, State versus Ackerman, A-C-K-E-R-M-A-N, 397 Southwest 3rd, page 617, 2012, Court of Criminal Appeals opinion, would absolutely mandate that the court shall, in fact, not allow that information to be presented. If it simply will not assist the trier of fact in making a determination of something that's relevant, or if it leads to confusion or misunderstanding. In the Ackerman case, it involved the testimony of an expert who wanted to testify about false confessions, about why some things, some psychological profile, something in a person's background might cause that person to give a false confession in regards to police interrogation. And in that case, the Dr. Frumkin, F-R-U-M-K-I-N, reiterated that he would not offer an opinion on whether the defendant's admissions were false, and he would only testify that the defendant in that case possessed psychological traits that made him more vulnerable to suggestion. And that is essentially what Dr. Turner has testified to in this case. That's because of some of the psychological traits of Mr. Wilbourn, that he might have been more susceptible to this so-called racial trauma, which is not a recognized mental health illness right now. Dr. Turner, so the court, has never been qualified in court as an expert in this field, has never testified in court. Turner is asking me to use this court as a guinea pig and to declare him an expert until that he's never testified as an expert, and say, Judge Coffey, you should declare me to be an expert and allow me to testify in this court. And what that does is open Pandora's box so that Dr. Turner can go to other courts and say, Judge Coffey, enough is clarified and testifying Judge Coffey in Memphis declared me to be an expert, and I've been declared as an expert, and I want to testify in other courts about something that is not recognized in the scientific community. And this racial trauma, in fact, is not recognized in the scientific community. It would be unfair, in the rules of evidence and rules of criminal procedure and mandate that those rules are meant to be fair to both sides, and it would be unfair to the state of Tennessee. It would put them in a position of a severe disadvantage. It would not be fair to the administration of justice if this information was given to the state about 2 weeks or so ago, and the state has not had an opportunity to find or locate or develop, and experts that would come to court and say this is not scientifically accepted. And that's the initial threshold that the court has to consider under McDaniel, MCDAN, IEL versus C as in California, S as in Sound, X as in Xylophone Transportation Incorporated. Have to consider that original threshold question, 955 Southwest 2nd, page 257, 1997 Tennessee Supreme Court opinion, as to whether or not this scientific evidence has in fact been tested, and the methodology in which it has been proposed has been tested. It has not. Dr. Turner told the court that more review needs to be done, more testing needs to be done. This is not something that is generally accepted in the scientific community. There is no indication as to what the potential error rate is, because, again, this is a developing field that may or may not gain any traction, but it is not. It's been established in the scientific community. And there's nothing before the court that would indicate that this testimony is, in fact, reliable. It is not reliable unless testing has, in fact, been done, and it has not been done. It's an ongoing field. It is not reliable if we do not know what the potential error rate is. It's not reliable if it is not generally accepted in the scientific community. And all of those threshold questions pursuant to McDaniel, in order for the court to even consider this as expert testimony to declare Dr. Turner's an expert, all the minimal basis cannot be established in this case. And based on Dr. Turner's testimony, he will be testifying on the basis of incomplete information. All of his testimony will be based on police shootings. There is no police shooting in this case. Dr. Turner indicated that he had not known, did not know, had not been aware of, even though the state had reviewed certain documents. Dr. Turner was not aware of the fact there was not a police shooting, was not aware of the fact that Officer Bolton never drew a gun, never fired a gun, never unholstered his gun, never removed various and multiple safety mechanisms from his gun that would even allow him to take the gun out of his holster. So Dr. Turner will be positing an opinion based on incomplete, based on inaccurate data, and he cannot get assured opinion as to whether or not this is true for Tremaine Wilbourn, that this in fact is true in this case. He told the court that he could not and he would never get an opinion. This court considered or dealt with a similar issue in the state of Tennessee versus 902478, and in that case, the defense wanted to call a witness, and again involved a alleged false confession that the defense in that case indicated that doctor, psychologist should be able to testify about false confessions and what could in fact lead to a false confession. That doctor in that case could not tell this court, as Dr. Turner cannot tell this court, that it is in fact applicable in this case. Dr. Turner cannot tell this court or this jury that Mr. Wilbourn was in fact suffering from some racial related trauma, and if it does not, cannot give a court that opinion, cannot give a court that testimony, and again realizing that the principles of due process requires that a defendant in a criminal trial has a right to present a defense and to offer testimony that is favorable to his cause, and that's Chambers versus Mississippi, 410 U.S. 284. 1973 Tennessee Supreme Court opinion of State versus Brown, BROWN, 29 Southwest 3rd, page 427, 2000 Tennessee Supreme Court opinion, that right to present proof and favorable evidence is, in fact, not absolute. That testimony must meet the same admissibility requirements as any other evidence would. And in this case, as in Mays, Dr. Turner, as a doctor in Mays, reiterated that he could not offer an opinion as to whether or not, in this case, Mr. Wilbourn was in fact suffering from some racial-based trauma. I've been asked to allow information that is not reliable, has not been fully researched, has not been fully developed, is not pertinent to Mr. Wilbourn, because there's absolutely nothing that Dr. Turner can say that would tell the jury to just talk to the jury. This is relevant. This is, in this case, Mr. Turner, Mr. Wilbourn rather was in fact suffering from racial-related trauma. It affected his decisions, his choices that he made on August 1st, 2015. And the court in Mays and Ackerman and Hall would indicate that that testimony simply is not admissible. And again, understanding that on sentencing on the capital murder case, that those standards are in fact relaxed. But I am not going to create a separate area of law. And if the Tennessee Supreme Court wants to do so, if the United States Supreme Court wants to do so, that says if you're a young black man and you meet a police officer, and that police officer is absolutely doing everything that he or she should be doing, not engaged in any hostility towards a person, not pulling guns, not shooting people, not unlawfully arresting people, but a police officer is doing exactly what he or she is commissioned to do, and that is to protect and serve. And they arrive on an illegal situation where people are illegally parked in a car with a bunch of marijuana in a car, and that police officer has an absolute right to approach and to investigate, to detain, and to arrest if there is probable cause those folks under those circumstances. I've been asked to carve out an exception that says if you are a black male, you have the right to shoot a police officer and kill a police officer, and says I did this because I am suffering from racial-induced trauma. I am not going to carve out that exception. If the Supreme Courts of the state of Tennessee and the United States of America choose to do that, that is obviously within their province, but this testimony is not relevant. It is not admissible. And under 403, it would in fact lead to confusion. It would lead to issues that the court has told the jury that they cannot base a verdict on, and that is sympathy or prejudice. The Memphis Police Department is not on trial this week. Police across this country are not on trial, and this is not, for the record, anything from the court that says that police officers are all upstanding, all good folks. There are good police officers. There are some not good police officers. All across the country get arrested because judges violate the law also. So this is not an indictment of the police department. It's not an indictment of the Memphis Police Department, but it is in fact unfair to allow a lawyer to tell a lawyer that you must provide discovery to the state, and the state has a chance to call an expert if they want to, and it's done untimely. It is unfair to the administration of justice to say I will let the speculative testimony in. I will let testimony to come before this jury that there is absolutely no scientific basis that says this is in fact reliable. But Dr. Turner says we are still investigating this, and no, sir, Judge Coffey, I cannot tell you whether or not this was something that Mr. Wilbourn was affected by. I cannot tell you that Mr. Wilbourn's decisions were affected or influenced, or the things that he did were somehow caused by some alleged racial-induced trauma. And for all of those reasons, this is simply not admissible. It would not aid the jury. In fact, would ask the jury to go back and make a decision based on emotions, based on sympathy, based on things that the court has told the jury they could not base the verdict on. The Memphis Police Department is not on trial. Officer Bolton is not on trial. Police across the country are not on trial. And I'm not at all suggesting that there has been some unlawful shooting. Excessive force has in fact been used, unfortunately, by many police officers all over the country, all over the United States of America. This is not that situation. And Dr. Turner's conclusions, his opinions, his suggestions, his speculation is based on an incorrect premise that Officer Sean Bolton was in fact engaged in a police shooting or was threatening to use force. And that is simply not this case. And for all those reasons, the court will exclude the testimony and with no deception for the record, Mr. Gangouli.
Thank you.
Yes, sir. Mr. Gangouli, you have an additional proof you choose to submit?
At the mitigation,
Yes, sir.
May we have a brief recess, please?
Yes, sir. We call the court into recess and work remain seated.
Court stands in recess.
For the record's continuation, State of Tennessee versus Tremaine Wilbourn. Mr. Wilbourn is present. Our trial counsel are present. Mr. Gangouli, does Mr. Wilbourn choose to present any additional mitigation proof?
Correct. Mr. Wilbourn asks to like chair of the court, please.
Mr. Wilbourn. Mr. Wilbourn, you've been asking for a couple of days that told me that you wanted to talk to me about something, wanted to share something. And I told you it's not a good idea unless you talk to people. Is that correct, sir? Now, is there anything, given that admonition, that you want to talk to the court and tell the court right now, Mr. Wilbourn? I'm sorry? Is there anything you want to tell the court, given the admonitions, the advice that I give you that it's really not a good idea to make statements and let your lawyers make those statements for you? Is there anything that you feel that you need to tell me, sir? Yes, sir.
I don't want to go into litigation because I don't feel that I've been getting a fair trial. I feel that nothing that we presented to the court that's been used, like everything has been rejected. I've been complete. They took the feedback. It's just saying I don't have states that they have received certain things that I want to aware of. So I don't feel like that. My lawyers, we have initial communication about certain things. So I just feel that if we can forego mitigation, I can be sentenced. So I want to continue to
Ms. Wilbourn, I don't have any control over the states indicating that they would consider allowing you to plead life without the possibility of parole. They told you that would be contingent upon the family acceptance of that. Do you understand that?
It is just one issue.
Okay, that's one issue, but I have no control over that. Do you understand that? I can't tell the state to allow you to plead anything. I have no control over that. Do you understand that? Now, Mr. Gangouli, Ms. Pastor was called to help prepare mitigation for you. And when you say you want to forego all of this, Mr. Wilbourn, that's 100% your decision. Do you understand that, sir? If you tell the court that you do not want your lawyers to present mitigation evidence, that is your choice. You have absolute control of that decision because that's a factual decision that you are allowed to make. You understand that? It would not be in your best interest, Mr. Wilbourn, to tell your attorneys that I do not want you to present any mitigation. That would not be in your best interest. You understand that, sir?
Yeah.
You understand the mitigation proof, Mr. Gangouli, Ms. Pastor, Ms. Hall have filed a notice of mitigation in this case that raises 21 potential issues. And they will call witnesses to testify as to why this jury should not sentence you to the death penalty. Do you understand that, Mr. Wilbourn? If you say, Judge Talk, I'm going to forego that, I don't want my attorneys to put on any mitigation. Mr. Wilbourn, the jury will be told that they find that the state has proven aggravating circumstances beyond a reasonable doubt, and the state is alleged free. If they find that aggravating circumstances outweigh any mitigation beyond a reasonable doubt, Mr. Wilbourn, this jury will be told they will have to sentence you to the death penalty. Do you understand that, sir? That's what the law says, Mr. Wilbourn. That's not what I'm saying. That's what the law says. And if you don't present any mitigation, you basically tell this jury that there's nothing for you to consider, and that's probably going to increase the possibility that a jury would sentence you to death. Not only mitigating circumstance, I could charge the jury, Mr. Wilbourn, if you made that decision, is that they consider any mitigation that may have been raised in the proof at either the guilt or innocence part of this trial by any of the parties, but I can't tell them anything in particular because there would be nothing that would have been presented. I would just have to tell them that any other mitigating factor which is raised by evidence produced by either the prosecution or the defense at either the guilt or sentencing hearing, that is, you shall consider any aspect of the defendant's character or record or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence. But that's the only thing I could give this jury as far as mitigation. And if they found that the aggravating circumstances outweigh that mitigation, Mr. Wilbourn, the law would tell them to sentence you to the death penalty. You understand that? It is not in your best interest to tell your lawyers, I don't want you to put on any mitigation for you. But that is 100% your decision. Do you understand that, sir? What do you want to do, sir?
I'm not sure they're going to be able to present it.
Mr. Wilbourn, your lawyers will present the mitigation that they are prepared to present, sir. I'm sure they told you what they intend to present, Mr. Wilbourn. I don't know what it is.
I'm saying you're going to accept them.
I don't know what it is, Mr. Wilbourn. I have no idea what your lawyers want to present, sir. But whatever they intend to present, they will present it for you, Mr. Wilbourn. I'm sorry?
You can speak with them, please.
You may step back and invite talk to your lawyers, Mr. Wilbourn. Call for the recess and work remain seated.
Remain seated. Court stands in recess.